My name is Darian Shookham. I'm an attorney at Weil Fotheringham, and we're going to talk today about transitioning an association from developer or declarant control to homeowner control. I am the head of the construction litigation department for Weil Fotheringham, so my focus is really on construction issues and not so much. I'm not so much an HOA lawyer, but I do have experience with turnover and some of the issues that go along with that. But really, I want to talk primarily about trying to avoid problems that can arise post turnover, particularly with construction issues and the common elements of an association. Got some more people joining, so let me admit them. Welcome to the people that just joined us. Again, my name is Darian Shookham with Weil Fotheringham, and we're going to talk about transitioning an association from developer to homeowner control. Give it one more minute to see if anybody else comes on, and then we'll get started. All right, so excuse me. Like most of us over the past year or so, I've been using Zoom a lot, but I am generally not the host, so I apologize in advance for any technical glitches. Somebody else is usually working the controls, but today I'm going to do the best I can with it. So again, the topic is transitioning or turnover. This is meant to be an introductory overview of some of the issues that arise around turnover. We're not going to get real deep into any particular subject matter, but we'll try to address the broad issues. The focus is primarily going to be on condo projects because there are more common elements and more issues that may arise as compared to other developments. But most of what we'll talk about is applicable to everything. We've got a few more people coming on. Okay. Terry, is there a way to set this to automatically admit people rather than me doing it manually every time?
Yeah, don't worry about it, Darian. I'll keep my eyes on it.
Okay. Oh, are you co-hosting?
Yeah, I'm just in the background.
Okay, good. Then you can correct any of my technical shortcomings. Okay, so to the extent questions arise that we don't answer today, or our discussion prompts questions, feel free to contact me. I'm easy to find here at the firm. My contact information, I think, is at the end of the slide presentation, and I'd be happy to answer any questions that arise. We can also talk about questions at the end of the presentation, and you can also use the chat function, and I'll try to take a look at those. Terry Rodriguez, our marketing director, asked me to tell everyone that the class is certified for CA/CM credit. So I will give out 2 code words during the presentation, and then if you email those code words to Terry, she'll send you a certificate. All right, so let's advance our slideshow here. That is me. Some of the things we're going to talk about today: what is declarant control, obtaining the necessary documents from the declarant or developer, insurance needs, budgets, review of building components, reserve funds, and meeting with the developer around the time of transition. So that we're all talking apples to apples, this is probably rudimentary for most people on the Zoom call, but we're talking about developer declarant control. We're talking about the situation when a declarant or developer creates an association, and then for the initial period, their representatives, the developer's representatives, are on the board, and the board and the association is essentially controlled by the developer. And sometimes as the project develops and units or homes are sold, excuse my sniffles, something is in the air today, owners may be appointed to the board, and then ultimately we have a transfer of management, if you will, from the developer representatives to a board that is made up of homeowners, and that's what we call turnover typically. And that can happen at a variety of different times depending on how the project is set up, how quickly units are being sold, what the declaration says about the timing of turnover. But it is mandated. There are certain deadlines mandated by Arizona law. It's at ARS 33-1243E, and turnover needs to happen at the earlier of 90 days after 75% of the units are sold, or 4 years after units are no longer offered for sale. The declaration can provide for an earlier date, but turnover cannot happen longer than those dates that are set forth by the statute. So one of the really important tasks for a newly appointed homeowner board to endeavor to obtain from the developer are all of the documents related to the project. And we've got a list here. Most of these are self-explanatory, but we'll talk about a few of them. We have minute entries from meetings by the developer-run board. We have the governing documents. That certainly shouldn't be an issue. I've never seen an issue where the new board couldn't obtain the governing documents. Building plans, subdivision maps, and landscape plans. This is important. It is very important that the board attempts to get a complete set of the plans from the developer, the architectural plans, the structural plans, and so on. Not only is it important for the board to know going forward about the various components that have been used in the construction of their community, but it could be very important to have those plans should a problem arise, so that whoever is investigating that problem has the information about, what was the design intent and how was the particular component supposed to be built. Sometimes a developer may give you pushback on providing plans, but there really isn't a whole lot of justification for that pushback. Those plans are typically provided to the building department for the particular jurisdiction and are essentially public record, or should be. So that's certainly something that we would want to make sure that the board gets upon turnover. Deeds to common areas shouldn't be hard to get. Utility bills are important. It does give the board some understanding and expectation about what the utilities costs are going to be going forward, and that may be part of the analysis for raising assessments in the future and determining budgets and so on. Warranties are important. In a typical project, in a condo project, there will be a warranty for the common elements from the builder, but also each individual unit owner would have a warranty for their unit. And then there also may be warranties for appliances, warranties for subcontractors and things of that nature, for the roof and so on. So those are certainly important things to get. A membership list, that's self-explanatory. Any legal files or collection accounts, I think that's probably self-explanatory. Contracts presently in effect, that would be obviously the vendors that are supplying services to the developer during their period of control of the association. And certainly the newly appointed board is going to want to review those contracts to see if they're fair, if they're reasonable, if they're providing the services that are needed going forward. Sometimes we find that there are sweetheart deals between the developer and an entity that may be the developer's friend or business associate, or another entity that's owned by the developer that is providing services that probably could be gotten for cheaper with competitive bids. So that's an important thing to look at early in the turnover period. Contact information for contractors involved in the construction, also very important. certainly in addition to knowing who was the general contractor that was hired by the developer, we would like to know who are the subcontractors and the suppliers that were hired by the general contractor, because those would typically be the people that ultimately, if there's an issue to be addressed, are going to come out and take a look and fix it if it's under warranty, or if they're directed to do so by the builder or by the ROC or whatever the case may be. So we certainly want to know who was involved in the construction of the project all the way down to the subcontractor and supplier level. Reserve study we'll talk about in a little bit, and in insurance policies we'll also talk about in a little bit. So as I mentioned, there are going to be two code words for the CACM credit. The first code word is GO, G-O. The first code word is GO, G-O. Okay. So moving on. So certainly want to know from the developer entities what insurance is in place. It's important for the board to know what the association has, what it costs, when it needs to be renewed, and also what you don't have or what you need. Not going to dive real deep into insurance coverage topics, but generally speaking, you would want to have property damage coverage, for the physical assets of the HOA, the common elements, the grounds, and so on. This is generally going to be more extensive and more expensive for a condo project as opposed to a single family home project or a townhome project, given the nature of the ownership of the common elements by the association. But generally speaking, the same sort of coverage is needed. For condos, you're probably familiar with the concept of bare walls coverage, where the structure itself is covered, but not the interior fixtures in a given unit. Or you can have an all-in policy where everything is covered, including all the fixtures inside the interior of a condo unit. There's general liability insurance that an association should have if somebody hurts themselves or there's property damage that occurs on HOA property or as a result of HOA property or HOA operations. Then to protect the association from those claims, certainly would want to have general liability insurance, director and officer insurance. This protects board members if they're sued for things that they did or didn't do during their tenure as a board member. And then employee dishonesty for theft or fraud by employees, officers, property managers. An important note regarding employee dishonesty policies is that they are typically for true employees, people that are receiving a wage or a salary. So we want to make sure that there is language in the policy or an addendum to the policy that covers board members or other persons that are serving without compensation. And certainly these things are going to be in place when the developer, or most of these things will be in place when the developer controls the association. But again, it's not just a question of whether they're there, but how much coverage is being provided, what's the term, what does it cost, and does the association need something else? And could that something else be cheaper or more suitable to the association's needs if put out for competitive bid to new carriers? Another important set of information and documents and so on to obtain from the developer and declarant entities are the budgets and the financials for the operation of the association. I think everybody on the call probably knows generally what a budget looks like. You have revenue, which is generally primarily the dues and assessments from members and maybe some interest. You have operating expenses, administrative expenses, maintenance, utilities, insurance, taxes, and so on. Reserve fund contributions. Again, we'll talk about reserves in a little bit. Then you have your total set of expenses or costs, and then a profit or loss statement, and that gives you a little snapshot of the financial picture for the association for a given point in time or a given year. And it is a good idea for an incoming board to review those financial statements. One thing we often find is that the assessments were set too low by the developer. Obviously, lower assessments make a community more attractive to prospective buyers. Conversely, higher assessments may make it less attractive. And so we find frequently that assessments are set too low, that operating budget needs are not being met, reserve fund contributions are not being met. And that is often something that a newly appointed board needs to address right away in terms of adjusting the assessments. Other red flags could be expenses incurred by the developer that were charged to the association that really should be developer construction costs or other costs. So, one example is the developer paying for maintenance or out of the association's budget for maintenance for things that are actually construction defects and should be covered by the developer or the developer's insurance carrier and not by the association. So certainly those are things that a board would want to review. And if the board doesn't believe they have the expertise to review financial statements, this may be a time to employ an accountant for that limited purpose of reviewing the budgets and the financial statements. So we'll talk about some of the building components and some problems that can arise and some red flags to look for in a little bit. But at turnover is a good time to think about the condition of the project that the association and the owners are inheriting from the developer. There is an 8-year statute of repose. It's similar to a statute of limitations, but it's finite. It has a finite starting and ending date. And that 8 years runs from the completion of construction or the certificate of occupancy for a given building or unit or structure. And so sometimes transition doesn't happen for 3, 4, 5 years from the construction of some of the first buildings. And so that statute of repose may be coming up within a short time frame after a homeowner board takes over. So you definitely want to know if there are any problems in the community that need to be addressed that are the result of deficient construction or deficient design, and should be the responsibility of the builder or its subcontractors or their insurance carriers, and not something that the association should have to pay for. Whenever we have boards undergoing transition, we recommend that they hire, or we hire on their behalf, someone like a home inspector, but somebody that is proficient in looking at multifamily units and the unique construction aspects of multifamily units. Generally, these are people that we use, that we have used for many, many years, people that are experts in sort of some of the problems that can arise in condo construction, and can observe and identify those things, hopefully before they become major problems. But certainly that's something that we would recommend that a board do around the time of turnover. That's something that I'll give a little plug for our construction law and construction defect law services. If we are handling a case for a homeowners association in Arizona, we typically do it on a contingency fee basis where we front the costs. And if we were going to be handling a construction defect case, one of those costs that we would front would be that initial inspection following turnover of the building components. So something to consider upon turnover by the new board. So reserves, I think we all understand what reserves are, but we'll do an overview quickly. These are funds that are set aside by the association to meet future financial obligations, primarily the repair and the replacement of the common elements. A common complaint again that we hear from new boards, or that we find upon turnover, is that the developer did not adequately fund the reserves. And so this means that the board's going to have to consider raising assessments and taking actions to bring those reserves up to where they need to be. Some of these things that we've talked about, the failure to set assessments correctly, the use of developer or the use of association funds for repairs that should be made by the developer, the failure to fund reserves. I mean, these could rise to the level of claims against the developer, depending on the circumstances. It would be a breach of the fiduciary duties that a developer owes to the association. And these are some of the ones that we see fairly commonly. So the reserve study is essentially made up of two parts. There's an evaluation, a physical evaluation of the property and the condition of the property, and an estimate of what the repair and replacement costs would be in the future, and when that would happen. And then, sort of in the same vein, there'd be a financial evaluation of the common elements and the estimated useful life of those common elements. And in that way, the person or persons that are doing the reserve study can determine when and how much something's going to need to be repaired or replaced, and then how much money is going to need to be set aside to achieve that goal. And that's essentially what a reserve is, and the purpose of a reserve study. We talked earlier about operating expenses, and of course the operating fund is different than the reserve fund. It is for the routine operation, the routine expenses of the association, not the future costs that may be incurred for repair and replacement. So the operating fund is dealing with management fees and maintenance and utilities, insurance premiums, and so on. So oftentimes, turnover will be accompanied by a meeting with the developer or the developer representatives. We strongly recommend that. We think that's a good idea. It's important to be communicating with the developer about the turnover process. Any information the developer has and is willing to provide about known problems or things to be addressed. Financial issues, collection activities, legal issues, and so on. Basically, the developer should be asked to download to the board as much information as possible, so that the board can hit the ground running and is not playing catch up in their tenure as a newly appointed board. And part of that meeting might include a walkthrough or inspection of the project with the developer. This might or could be done with a person or persons that are hired by the board as construction consultants, or it could just be done informally with the developer. But either way, it's good to walk the property, identify any problem areas, get commitments from the developer regarding repairs, and so on. Anything that can be resolved early on, informally, without a dispute or without a legal process, is obviously the preferable and more cost effective way to resolve the problem. We have seen those issues become contentious, post turnover or in the time frame of turnover. And sometimes the developer will agree to make repairs, but then will want a release for those things. The association, the board, should be very careful about signing any sort of, quote unquote settlement documents or release documents. And that's certainly something that the board may want to have an attorney review. And, it's very likely that the developer has his own attorney that has been handling association affairs. This may be a situation where the newly appointed board needs to hire a different attorney for the newly appointed board and the association going forward. But obviously that has to be addressed on a case-by-case basis. But, as the bullet points stay here on the slide, you certainly don't want to sign off on things that contain legalese and maybe the layperson board doesn't fully understand without attorney input. Okay, our second code word for CACM credit is SUNS, S-U-N-S, exclamation point. SUNS, S-U-N-S, exclamation point. So the two words are Go Suns, and the playoffs are coming up, and hopefully we'll get a deep run by our Suns. All right, so we're going to talk about some construction issues. Excuse me for 1 second. I'm looking to see if we have any. All right.
I'm monitoring the chat for you, Darian.
Okay.
If it has any questions, I'll let you know.
See if we have any questions. I see some questions. I'll take a look at those at the end and we'll address those. Okay. So really the primary thing that I wanted to talk about is trying to identify and get ahead of potential problems. It's always easier to prevent than to repair or fix or modify problems after they come up. Certainly if a potential roof issue can be addressed, that preventative maintenance may, save the association from a situation where the roof, a common element, is letting water into somebody's unit. And now you've got an angry unit owner with a potential claim against the association because the problem arose from issues in the common areas. So, the building envelope in its entirety, of course, needs to be weatherproof and waterproof. And that would include roofs, windows, decks. One thing we don't have on this PowerPoint slide is stucco or exterior finishes, which maybe it was my fault when we created this, but in any event, that's something we should talk about as well. Stucco issues and exterior finishes are not the primary avenue of water intrusion in my experience. It's more often roofs and windows and decks, but they can be. And a lot of projects are covered extensively by stucco, and even if it's only a cosmetic issue, cracking stucco or deteriorating stucco is unsightly. It is a problem for the appearance and the attractiveness and the value of the community and the homes they're in. And even as a quote unquote cosmetic issue, stucco issues can be costly to remedy. So that's something to look at early on in the life of the project. So we see a lot of flat roofs in condo projects in Arizona. Just as an aside, I've represented many associations, construction defect claims. We had one recently up in North Scottsdale. It had flat roofs. The homeowners had reported leaks at various times. We got into a litigation with the builder. They kept telling us, no, roofs don't leak, roofs are fine. Anything is just a maintenance issue or minor issue. We were supposed to go to trial, or really technically arbitration, but we'll just call it trial for ease of reference. We're supposed to go to trial on a Monday in January. I think it was Monday the 26th. I mean, it might have been the 25th, this past January. That was the day after we had a huge storm in town, and especially in Scottsdale. And there are, I think, 29 upstairs units at this particular project. 20 of the 29 upstairs units reported leaks from their flat roofs from that storm at this project, where we were being told there weren't any problems. And the builder actually had to ask the arbitrator to delay the arbitration, the trial, so that they could assess what was going wrong with the roofs and figure out how they were going to respond. And obviously that gave the arbitrator a sense that our position was much more credible than theirs, and we got a very good result in that litigation. But the point of that is that where there's smoke, there's fire. If there's repeated reports of leaks, especially early in the life of a project, and turnover typically happens fairly early in a project, it's probably not isolated. There are probably issues that need to be addressed, and whether the developer wants to call it maintenance or whether it is in fact a defective installation, so that we can avoid a situation like I just described in the past, back in January, where we had massive water intrusion. It's something that the new board, hopefully through the cooperation of the developer, can get onto quickly. But in a flat roof system, a typical installation is that there is a topping material that's applied in different ways. Sometimes it's by heat. It's called a torch down method. Sometimes there's a built up roof. But these roofs have seams, they have intersections of flat portions to the parapet walls, they have drainage areas, they have scuppers. And so there are a lot of, it looks, when we look at it in this diagram, it looks very simple, but it actually is fairly complex. Clearly needs to be waterproof. The water needs to be moved in the correct direction towards the drains or the scuppers. There are, code required slope percentages to make that happen. So those are things that need to be checked. The intersection of the flat roof to the wall needs to be flashed. The drainage and the scuppers need to be, or the drains and the scuppers need to be properly sealed and flashed. And any of those areas can result in water intrusion if not done correctly. These are things that need to be maintained by the association going forward after turnover, and can be, can especially be a problem if the roof is too flat. So if that slope we talked about, moving the water off the roof is not accomplished, and water is sitting on the roof, which in and of itself could be a code violation or ROC violation, depending on the width and the depth and how long it sits there. But putting those details aside, any standing water for any period of time on a roof after a rain can be a problem, and something that the newly appointed board wants to take a look at. And here's an example of that: water ponding on the roof and not getting to the scupper. And so if you've got any vulnerability or weakness in that area in the roofing material, that's a place where water can get in. And even if it's not actually getting into the interior of somebody's unit, if it's getting to the substrate, to the framing, it's causing deterioration, and it's creating a situation where ultimately the association is going to have to make a repair or replacement earlier than they probably anticipated, or earlier than is estimated in the reserve fund. And obviously that creates a situation where you're going to have a potential budget shortfall. So again, much better to try to identify these issues early on and address them early on before they become a problem. You can have problems on sloped roofs as well. We don't tend to see a lot of high slope or severe slopes in roofs in Arizona. It's more what we call low slope. So this diagram is probably a little bit misleading, but slope roofs also can be areas of water intrusion. You don't have necessarily the same problem where water is sitting like on a flat roof, but there are vulnerable areas, and where you see valleys or areas where water may become stopped up. You need to have proper flashing, sealants, and so on. This diagram shows some of those areas where water intrusion is sometimes found, and so all those areas should be inspected to see if they're correctly flashed. And of course, you want to make sure that you don't have debris that's blocking drainage down the valleys and so on. We don't find as many problems with sloped roofs as we do with flat roofs, but it can be a problem. One problem that we see is a lack of underlayment. A low sloped roof requires 2 layers of underlayment. That's the sheeting beneath the shingles or the tiles, typically a felt-like material. And a lot of builders try to get away with just using 1 sheet. Sometimes they use a heavier sheet and make the argument, well, that heavy sheet equals the 2 lesser sheets or lighter sheets, but that's not what the code requires. There's a reason that they want 2 sheets, and if that's not done and that underlayment is not proper, then any water that gets underneath the shingles or the tiles, it can get directly to the sheeting, and that'll be a problem. So that's something to look at. And all these things are fairly inexpensive. A roofing consultant can come out and pick a few locations. They don't need to look at every square foot of every roof, but can do spot checks of the roofs around the community. It's not particularly expensive to lift up tiles or shingles, to check out the underlayment and the flashing and so on. And again, prevention is much better than dealing with the problem down the line. We find a lot of problems in windows, typically because they're not flashed properly. The intent with the stucco wall, which we usually see, but in most exterior wall finishes, that any water that gets behind the exterior finish will run down along the building paper and then out the bottom. It's through what we call a weep screed in stucco, but that is dependent on the building paper being installed in the correct manner so that the water can run down and run down the paper, not into the cavity. And so if you get paper around windows that's what we call reversed flashed, where the opening is facing up rather than down, water can get into those areas. Or if you have building paper that's been penetrated by nails or ripped or cut, excuse me, all those areas can be problematic. That's a little bit tougher for somebody to do in a preliminary type inspection or a walkthrough type inspection. I mean, to see the flashing requires the removal of the stucco or whatever the exterior siding is. So that's a little bit more involved and more expensive. That might be something that you would only want to do if you have indications of water intrusion into the interior, reports from homeowners or what have you. But that is a very common problem. And all of these things with the building envelope, whether it's roofs or windows or decks, it is counterintuitive in our climate to think that water intrusion can be a problem, but it can be. And when we do get storms, they're often violent and heavy and wind driven. And so, all the same concerns that you would have building anywhere, you have in Arizona as well. You need to have a waterproof or weatherproof, at least, building envelope. And again, these are the areas where we typically find problems: roof, windows, decks, and then sometimes in the stucco. This is just a diagram of a deck structure. Again, like with roofs, you know, your deck looks fairly simple, or anybody's deck looks fairly simple, but it's not. There's sort of a lot going on, and a lot of areas where you can have potential water intrusion if the flashing and sealant is not done correctly. Again, a little bit of background noise. If everybody can mute unless they need to ask a question, I'd appreciate it. Like with, still got some background noise. Somebody can correct that, please. Okay, so like with the roofs on a deck, you know, it's important that you have the slope, moving the water away from the structure, and then anywhere where there's a intersection of the deck. Still got a lot of background noise from somebody. Can everybody please mute? Actually, I'm going to mute everybody and then see if that helps. All right, that's better. Okay. So these are things, you know, like with the roof, it's fairly easy to do a spot inspection. Anybody can put a level on a deck or a roof and see if it's sloping away from the structure. You can see signs of ponding water on the decking materials. And of course, if there's been an indication of water intrusion into the, you know, living space or garage or what have you underneath the deck, then that's obviously a clue or indication that there's a problem with the deck itself, and certainly something to investigate. So certainly something that should be looked at, and is a little bit easier to look at than the windows. Grading and drainage, probably the primary issue we've been dealing with in recent years, more so for single family homes than condo projects or multifamily projects, but still an issue. The issue we have in the Valley and in lots of areas of Arizona and lots of areas in the Southwest are what are called expansive soils or clayey soils, and they act like a sponge. So when they're dry, they're compact, and when they get wet, they expand. And it's not something that, you know, would prevent or prohibit from building on the site where there are expansive soils, but there are things that need to be done to mitigate that. And most of those things, the end goal is to move water away from the structure or from the foundation. And we just find that that is not happening very often. We find in both single family home projects and in multifamily projects, you know, very flat lots. They do not have the required 5% slope away from the building that's required by, you know, every jurisdiction's code, and often don't have gutters and downspouts to move water away. You know, a lot of times, if they do have scuppers from flat roofs or gutters and downspouts, like shown in this diagram, the downspout is depositing the water right next to the home and not moving it away. And this is, you know, this is especially a problem if the slope is flat or the slope is towards the structure in the grading. So those are things that anybody can really eyeball. You know, even a layperson can eyeball the slope away from a building or their home and see if it looks like it's going to move water away or not. But the code requirement is 5%. Frankly, if we see 2% away from a structure, we're pretty happy, because usually even that's not met. And so on the expansive soils, you know, it's a result of the expansion of the soils putting upward pressure on the structure, and as the slab moves, it causes the framing to move and causes damage in the stucco and the drywall and tiles and so on. Excuse me. More so a problem in single family homes than in bigger structures. So if you have a, you know, multi-story condo building with multiple units, and it's got a, you know, a lot of weight pushing down on the footprint because it's multiple stories, that's going to generally resist the upward pressure more than a, you know, a single family, single story home. But you can still have problems, and what you'll often see, even if you don't see the evidence of the expansive soils in the structure itself, you'll see it in the flat work. So your driveways and your sidewalks and your planters and your streets may show evidence of that soil moving and causing heaving of sidewalks or patios, any flat concrete element or cracks in the streets and so on, which could be an indication of expansive soils, or could be an indication of poor compaction and poor drainage, but in either event, something that needs to be corrected. We also have in the valley collapsible soils, not as common as expansive soils, but if you have collapsible soils, that is more of a threat to a multifamily building, a larger building. So it's the opposite situation of what I talked about with the expansive soils. Now that weight pushing down is going to work against you, because those soils want to collapse when they get wet, and they've got more weight pushing down on them, and more stimulus to cause them to collapse if they get wet. And that's what happens when collapsible soils get wet. They liquefy and collapse, act like a liquid. Can also happen in earthquakes. Not as much of a concern for us here as in some other states, but earthquakes can cause soils, and especially collapsible soils, to liquefy from the jiggling, and obviously that is a problem for the building sitting on top of those soils. So certainly, a newly appointed board wants to look around their project. It's pretty easy to identify areas where you have ponding water, especially after a rain, and where you have ponding water against the foundation needs to be addressed. Even in a retention area where water is meant to be, if it's not dispersing or draining quickly enough, that obviously is a problem for mosquitoes, for foul odors, for kids playing in it and getting hurt and so on. So that can be a nuisance as well and should be addressed. But in terms of causing damage to the building, water against the foundation is a problem. And it's a problem, regardless of whether you're on soils that were classified as expansive or collapsible. Even where the soils have no adverse qualities, determined by the soils engineer, that 5% code requirement of the slope away still applies. So this is sort of a diagram here of what you want to see around a structure or a home. You want to have the grading moving away from the home, and then, to the extent the water needs to continue to move away or off the lot or away from the structure or to a retention basin, what have you, that's done through what we call swales. If it goes to the street, then you'd have, gutters and so on, but all with the intent of moving water to its ultimate destination. All right, so you have contact information if you need to contact me with any questions that we don't address or anything that comes up in the future. I'm going to give you a better phone number than this. This is the general office line. My direct line is 480-272-6024. Feel free to contact me about any concerns about turnover or construction issues in your communities. I'd be happy to answer them via phone or email. I'll look and see if we have some questions here in the chat. Bear with me as I run through these.
Darian, there was one about somebody has associations that require, or it says they require their HOA turn at 100%, and they were curious if that went against the Arizona revised statutes.
Yeah, so let's see if we can answer that by looking at the language. So again, the declaration can provide an earlier date, but it can't be later than what's provided by the statute. And the statute is 90 days after 75% of the units are sold. So that would seem to suggest that you cannot wait to 100%, or 4 years after units are no longer offered for sale, which I think that would be not applicable in this situation, because once 75% of the units are sold, to get to that 100%, the 90-day clock would start running. So I think that is contrary to the code requirement. The second part of that question says the PPT would be nice.
The PowerPoint, I did share in the chat a PDF of your presentation. So anybody who wants that should be able to
Okay.
download it.
But everybody was able to see it while we were talking?
Yes.
Okay, good.
Yeah.
All right.
There's another question. It says, do you recommend an engineer or general contractor to do the audit and inspections?
Yeah, I would say generally a general contractor for those preliminary inspections. I mean, if you have a known movement problem, then you may want to engage a geotechnical engineer or a structural engineer. But for sort of preliminary inspection purposes where the person needs to be a sort of a jack of all trades and look at a variety of components and areas in the project, we typically would go with the general contractor. And you know, we have recommendations for anybody that has that need.
There's another that says, at the time of turnover from declarant to HOA, and the builder had advertised low assessments, yet they underfunded the reserves. What recourse do you have to obtain the monies that should have been set aside?
Right. So, I mean, that would be, you know, in the situation of turnover and, you know, the newly appointed board identifying these financial issues and, you know, assuming that that the clock hasn't run on statute of limitations and sort of things like that. But just in a vacuum, the claim would be for breach of fiduciary duty. You know, again, the developer slash declarant owes an obligation to the association and the members to protect their interests before, or to an equal measure to the developer's interests, and that includes financial issues. That includes the setting of assessments, the funding of reserves, some of those issues we talked about earlier, not having sweetheart contracts with vendors, not spending association money to be used by the developer to make repairs that should be paid for by the developer, and so on. So, you know, obviously, if a claim like that or a situation like that arises, a board identifies a financial discrepancy or potential discrepancy, that's something you want to talk to an accountant about and or a lawyer. And if there is a true discrepancy and the builder is unwilling to voluntarily correct it, then you have a legal claim. Breach of fiduciary duty would cover it. It could also be a breach of contract if it violates some provision of the declaration. Could be a fraud claim or a negligence claim, depending on the circumstances. But there absolutely is a legal claim to recover those funds. Let's see. By the way, I know in the invite for this, it was titled "The Departed." I think our marketing department has been linking movie names to these programs. So hopefully nobody was coming today to view a showing of The Departed or to have a discussion about The Departed, which is a great movie, but and one of my favorites, and a great performance by Jack Nicholson. But we didn't mean to mislead anybody if you were looking for something different. Let's see what else we have here.
There's one question from, I think it's Lincoln Rath, but he may have to ask himself. All it says is that specific to condos? Do single family homes fall under this as well? So that's kind of broad. I'm not sure what he's referring to.
Yeah, that statute that we talked about requiring turnover at the earlier of 90 days after 75%, or 4 years after the units are no longer offered for sale. That is from the Condominium Act. So I have to confirm whether other planned unit developments have the same requirement, and I can contact the person that asked that question and get back to them. Let's see. Somebody asked a question, what if the declarant holds on to the community until the statute of repose expires? Can the HOA sue the declarant, or is there no recourse? Yeah, that is a good question. There is a tolling of the statute of limitations during declarant control. But the statute of repose is finite at 8 years. And so I think in the situation where the declarant held it for 8 years, the HOA could possibly be out of luck. Now that 8-year period is only for contractual type claims, and not for negligence or fraud or breach of fiduciary duty. So if the issues are financial as opposed to construction, the 8 years wouldn't apply. But yeah, that could be a problem if the declarant has held on to the community that long, which is why it's important for for members of the community and property management to be aware of when turnover is supposed to happen and whether it's being improperly delayed, and to make sure that that happens as per the declaration or the statute. All right, we're running up on our hour here. Thank you everybody for joining us. Again, if you have any additional questions, things you want to discuss, either in theory or specific to a community, please contact me. I'm happy to discuss it further, and I hope this was worthwhile for everybody. And make sure you email Terry with the code words "Go Suns!" and get your CACM credit. Thank you, everybody. I'm going to sign off now. Have a great day. Bye-bye.